Sorry about that, I was muted. Welcome everyone to our final webinar in our Spring Student Loan Webinar Series hosted by the DC Office of the Attorney General and the DC Department of Insurance, Securities, and Banking. My name is Lindsay Marks and I'm Consumer Protection Attorney with the DC Office of the Attorney General. Our office investigates and prosecutes businesses who engage in deceptive or unfair business practices towards district residents, and that includes student loan servicers. We frequently work with DISB to educate district borrowers on student loan issues that we're seeing. This is a four-part series, and today we're talking about the rights and protections that you have as a student loan borrower. Our prior webinars were recorded and have been posted on the webinar series registration page, and I will put that link into the chat. And now I'll turn it over to DC Student Loan Ombudsman to introduce herself and kick off the presentation.
Amazing. Thanks so much, Lindsay. Hi, everyone. My name is Jessie Myers. I'm the Student Loan Ombudsman for the District of Columbia. Our office sits in the DC Department of Insurance, Securities, and Banking, or DISB. We're the district's financial regulator. The Office of the Student Loan Ombudsman, one of our statutory authorities and duties is to support student loan residents in understanding both their responsibilities and also their rights. So that's what we'll be talking a lot about today, is what those protections are as a district resident, as well as at a federal level, and what resources are available to you. So with that, let's get started. So this is the last webinar in our four-part series. As Lindsay mentioned, for the first three webinars that we posted, we covered a variety of topics. For webinar 1, we talked about managing delinquency, accessing affordable repayment options, navigating forbearance. In webinar 2, we talked about changes that are impacting Parent Plus borrowers. In webinar 3, we talked about upcoming changes to repayment plans, specifically income-driven repayment, and how that impacts borrowers pursuing public service loan forgiveness. All of those recordings are available. We threw the link here and Lindsay put the link in the chat. Definitely go check those out. We'll also be posting this on the DISB Student Loan Ombudsman page as well. They're available for free and are on YouTube, so please check that out. Today, we wanted to end on focusing on rights and protections. So we covered a lot of different subject matter related to student loans. But we also wanted to hit on okay, but what happens, say, if you are pursuing public service loan forgiveness? And as we discussed, you're required to make 120 monthly payments for the remainder of your balance to be discharged. But what happens if your payments aren't being posted on your account, or you're worried they're not being posted accurately, or you have questions about it with your servicer, but your servicer isn't getting back to you? And so that's why we wanted to end on this topic today, so that we could cover what those protections look like and what avenues and resources are available to you if you have concerns about practices that you're facing with a student loan servicer, or in accessing forgiveness and repayment and deferment and forbearance paths that are protected by law. One thing I want to note is that both DISB and OAG do not have the legal authority to represent you as an individual and cannot offer legal advice. So should legal action become necessary, you may need to consult an attorney. And so the purpose of today is to outline for you what those rights look like according to the Student Loan Borrower Bill of Rights. And we'll get into what that is, what protections that affords to you as a student loan borrower and district resident. Before we get into those protections, quick note on language, we'll be talking a lot about servicers versus lenders. We'll be talking a little bit about, programs that are administered by the Department of Education versus programs administered by student loan servicers. I really shouldn't even say versus. Servicers are contracted out by the Department of Education. To not get into the details there. We wanted to kind of break down what different entities are doing in this space. So you as a borrower, you've taken out a loan to pay for educational expenses. You have a responsibility according to the master promissory note, and that helps guide your repayment terms, which are set by the lender. Today, we'll be talking about both federal student loans and private student loans. In the federal student loan context, in most cases, generally, the lender is the Department of Education. There might be some circumstances if you have, FFEL loans or Perkins related to other types of lenders and servicers. If that's the case, then definitely reach out to us for any questions that you might have. But generally, the case is that Ed is the lender, and most people have direct loans if you look at the type of loans you have. The servicer is who you're probably familiar with and interacting with. For many folks, with direct loans, that's going to be MOHELA, Advantage, Ed Financial, Nelnet, and CRI. A lot of what we're talking about today relates to practices related to your servicer. And this comes up a lot when we work with complaint escalations of kind of like, okay, well, on this aspect, we can work with your servicer on, say, correcting payment history or loan statuses. But depending on the program or the specific issue that you're facing as a borrower, that might change the avenues that are available to us in terms of being able to escalate your complaint and to take action. So we'll get over specifically in the ombuds role what that looks like. At a high level, though, you have rights as a student loan borrower in the district. The Student Loan Borrower Bill of Rights in DC outlines what these rights are. You can check out what these enumerated rights are in the following codes listed here. The one thing we wanted to note is that the prohibited conduct, there's a section for student loan servicers generally related to prohibited conduct and affirmative duties. And then these protections are expanded for private education lenders and private loan servicers. And so if you have questions about this, definitely let us know, but we wanted to make that clear. But nevertheless, regardless of whether you have federal or private loans, there's a minimum protection, I would say, afforded to you as a student loan borrower in the district. Before we talk through what those protections are, a quick note on, as ombuds, what our office's role is. So in terms of our statutory authority or our legal authority, we have the ability to help borrowers understand what your repayment plans are, forgiveness or discharge eligibility, what your rights are, what your responsibilities are under the loans contract. We can help support communication with your student loan servicer. We can help escalate complaints that you have related to the servicing of your loan to the student loan servicer. According to the district statute, this also includes other entities in the student loan servicing system that we can escalate and communicate your complaint. We can conduct education and outreach as we're doing today and connect borrowers with available resources. We do have limitations in our role. We cannot provide legal or financial advice. We are not able to expedite or confirm student loan forgiveness or discharge. So for a lot of different programs, the Department of Education is the determinant of decision-making for certain programs. And so we are not able to fast track that or confirm. What we can do is educate you on what, according to statute and regulation, the different parameters or qualifications are for different programs. And so given that, we can say, okay, well, maybe this is an escalation to a service or help guide you in the right direction. We can't process or expedite refunds related to, say, like if you've made an overpayment for student loan, public service loan forgiveness, we can't expedite refunds, and we can't hold collections for student loan for student loan borrowers in default. Okay, so with that, we're going to talk about what your rights are as a student loan borrower in the district. We thought it would be helpful to start with what commonly reported complaints that we see with servicers and protections available to you as borrowers. So, for example, we hear from folks related to long hold times that you might be facing. You might call your servicer with a question, and you might be facing a long hold time, maybe even to the point where you can't wait that long and you have to abandon the call, you have to hang up. That's something we hear about. We hear from borrowers report non-responsiveness to their inquiries or complaints that they themselves bring to their servicer, or that the response they received, we hear reports that they didn't fully address your complaint or didn't fully or accurately address your complaint or inquiry. We've heard from borrowers related to inaccurate credit reporting, for example, either positive payment history, for example, or that your credit report isn't accurate. When you're looking at, it's called your trade lines, when you're looking at your credit report and you see your student loans listed, inaccurate information we've heard from borrowers that they have seen. The list goes on related to payment processing. So for example, in the 2024 Consumer Financial Protection Bureau Student Loan Ombudsman Report, one of the biggest issues that particularly federal student loan borrowers faced was related to repayment. And this included things like payment processing errors or issues with auto pay. So if any of these apply to you, we wanted to list them here to say, okay, if I'm facing this, there might be protections available to me, and perhaps I should explore additional steps in terms of exploring resources that are available and remediation for issues that you might be facing. So what are these rights and protections? As a student loan borrower in the district, we want you to know that student loan servicers are prohibited from engaging in unfair or deceptive practices. They are also prohibited from misrepresenting material information. So this could include the amount, the terms, payments, conditions, or obligations of a student loan. We talked a little bit about customer service. So, as folks on the call might be aware of, as a borrower, you have the ability to call your student loan servicer on the phone. You have the ability to message them. So when you go to your servicer's website, there's an inbox where you can submit a message. As a borrower in DC, we want you to know you are entitled to timely information, complete and accurate information as well. A particular right and protection we want folks to be aware of is related to written inquiries. According to district law, if you submit a written inquiry to your student loan servicer, there's two things they must do. One, they must acknowledge receipt of the inquiry within 10 business days. And then they must provide information relating to the inquiry, and if it's applicable to what you wrote in about, the action they'll take or the explanation of the determination that your account is correct within 30 business days. And that should include copies of all information and account information used to reach that determination. When it comes to payment application, so as we mentioned, as a borrower, you have a responsibility to make payments according to the contract of your loan. So you'll send in payments to your student loan servicer. Servicers cannot misapply student loan payments to your outstanding balance. We also hear a lot from borrowers that have been transferred between servicers. There was a lot of transfers that borrowers experienced, particularly during the COVID payment pause. In the district, you have protections related to when your loans are transferred between servicers. There are obligations in terms of both what the outgoing servicer has to do, as well as your new servicer, what they have to do in terms of timelines of making sure they have all applicable information and making sure that the completeness of that information as well. So you want folks to be aware of your rights available to you if your loans are transferred between servicers, that you have protections according to district law. Credit reporting. Servicers cannot furnish inaccurate information to a credit bureau, harming your credit worthiness. We'll talk a little bit later about how you can check your credit report and to confirm the accuracy of information. In the district, student loan borrowers have a private right of action, which means student loan borrowers in DC have the legal right to sue student loan lenders or servicers. So we wanted to call those particular protections out based on what student loan borrowers in the district report in complaints to our offices. We want folks to also be aware that that was not comprehensive. There are additional affirmative duties and prohibited conduct for lenders and servicers in the district. So we listed some additional ones out here. The ones with asterisks, as we mentioned earlier on, there's this baseline according to district law of what student loan servicers must do, and then there's prohibited protection in the private market. And so the protections listed here with asterisks are those expanded protections. We also included a link if you're like, okay, well, how can I read the text of the law to know what this says? We included a link here so that you're aware of what those affirmative duties and prohibited conduct are in the district. So that's district law. We're also going to cover and dive into what federal rights and protections are available to you in the federal space. So for example, the Electronic Fund Transfer Act, or EFTA, provides different protections for you. Specifically, and most commonly what we hear about for student loan borrowers and complaints that we receive is auto payment protections. So we want borrowers to be aware that any auto pay transfers from your account require your written authorization. You have the right to dispute auto payment errors. And there are also protections related to the investigation of that dispute. If the amount of your auto pay will differ from the last transfer under the same authorization, the servicer must provide written notice of the amount and date at least 10 days before the scheduled transfer date. So in other words, if the amount is changing from your last transfer and it's under the same authorization, so there isn't a new written authorization, that written notice must be provided at least 10 days before the scheduled transfer date change, either the amount or the date changing. You also have the right to stop auto payment. There are additional protections under the Fair Credit Reporting Act, or FCRA. You have the right to dispute incomplete or inaccurate information. Consumer reporting agencies must correct or delete inaccurate, incomplete, or unverifiable information. And servicers must generally investigate and respond to a credit dispute within 30 days of receipt. We say generally here, there is a provision where if additional information is provided, this can be extended out to 45 days, but generally 30 days is the timeline for investigating disputes. Okay, so we've talked a lot about credit reporting, and we talked about how we've heard from district borrowers that there are reported inaccuracies or reported potential errors with credit reporting. So the way you can check that is you can request a free weekly online credit report at annualcreditreport.com. This is a screenshot at what the top of the page looks like. So it'll list your credit reports from Equifax, Experian, and TransUnion, which are, three major national credit reporting agencies, or NCRAs. And federal law requires each of the three of these NCRAs, is sort of the shorthand, but the three nationwide consumer credit reporting agencies to give you a free credit report every 12 months if you ask for it. Currently, the website lists free weekly online credit reports, but there's also this protection according to law of your ability to access an annual report on a 12-month basis. But right now, there's a free weekly access. Okay, Fair Debt Collections Practices Act, or FDCPA. So borrowers might have been receiving notices that they're in delinquency or entering default on their student loans over the past few months. So we wanted to make folks aware of protections on the debt collection front as well. So as always, you have a right to timely, accurate, and complete information about your loans. In the debt collection space specifically, debt collectors cannot contact you before 8 a.m. or after 9 p.m. unless you agree to it. Debt collectors can't contact you by email or text if you ask them to stop. And debt collectors can't call you more than 7 times within a 7 day period or within 7 days after reaching you and contacting you about a debt. That means actually speaking with you about that debt. We also wanted to make folks aware there's, a lot in the news, I think, particularly over the past few months about public service loan forgiveness. Both public service loan forgiveness or PSLF and other discharge programs and other protections related to deferment, forbearance, exiting default. There are protections written into law and are set by law about, for example, what the qualifications are for PSLF. So we wanted to make folks aware of that as well. Okay, so we're going to end on resources. Okay, so we have a lot here. So let's say you have concerns about a practice that you're facing with your student loans, particularly as it relates to a student loan servicer. There are different avenues you can take. For one, you can always reach out to us at DISB and the Office of the Attorney General. You can call us, email us, submit a complaint at our websites. And what we can do is at the very least point you in the right direction to help you out with what your complaint or concern is. You can submit a complaint directly to the U.S. Department of Education at the website listed here. The Department of Education also has an Office of Inspector General hotline related to fraud, waste, and abuse. If you have concerns about that, you can submit a complaint at the website listed there. I believe they also have a phone number you can call if you visit their website. The Consumer Financial Protection Bureau, or CFPB, also receives complaints related to student loans. Those get routed to your student loan servicer or the Department of Education as needed, so you can submit a complaint there. The Federal Trade Commission receives complaints related to frauds and scams. So if you have concerns about that, please report to the website listed for the FTC. And as we mentioned, you, as a district resident, have a private right of action as well. And so if if you're concerned, you can consult an attorney as well as about practices that you're facing with your student loans, particularly as we mentioned in the district, DISB and OAG do not have the ability to offer legal advice or provide individual protection or individual representation. Okay, so we listed a few additional resources here of different groups in the space. Protect Borrowers, the National Consumer Law Center, NCLC, EdCap, and TISLA also provide free and available online resources related to your rights with student loans, action that you might need to take. So we just wanted to make people aware of these resources as well. So thank you all so much for joining us these past few weeks. Again, all of these recordings are available online. So if you weren't able to attend or you were like, those were so handy, and want to distribute with other district residents that you know, friends, families, loved ones, please feel free to do so. They're online for free and available. I think with that, I'll turn it back over to Lindsay.
All right, if you have any questions on what you've heard today or even a past webinar, feel free to put that in the chat now and Jesse and I will answer them. No questions so far. If there, oh, somebody is typing, but I was going to say if there are no questions, or if you have a question you don't want to put it in the chat, you can always email Jesse at the DC Loan Help at dc.gov or me at consumerprotection@dc.gov.
And we understand for a lot of folks, it might be like, I'm not sure, like I'm experiencing this, and we totally understand. So feel free to reach out if there's anything that you're experiencing.
All right, so here's a question about public service loan forgiveness, which we did have a webinar on last week, Tyler. So I encourage you to find that recording in the link. But he was wondering, do the months that we are on forbearance count?
That's a good question. Generally, it depends, like so many things in the student loan world. So for the SAVE forbearance, for example, no, but you can explore a program called Public Service Loan Forgiveness Buyback, where you can buy back certain kinds of deferment and forbearance. And so we can put a link to that in the chat, but that would require you, it's a specific program. There's certain eligibility requirements for that related to like when it's available, and it would also include paying the amount that you would have paid under an IDR plan for those months in deferment or forbearance. And again, and not all forbearances count. A lot of folks who are reaching out to us are wondering about the SAVE forbearance, for example. So like the SAVE forbearance would count under buyback in particular. But generally, no, like the SAVE forbearance time wouldn't count. But the payments you made under SAVE prior to the forbearance period, which I think at the top of my head was June 2024, should count towards PSLF.
And just for clarity, there are a lot of different types of forbearances, and some do automatically count, like a processing forbearance would count towards PSLF. So if you aren't sure what kind of forbearance you're in, you should contact your servicer.
Yeah, absolutely. And so, like, a good rule of thumb, for example, is that generally, I believe borrowers should be placed in a processing forbearance when you submit an income-driven repayment application. And so, if you are, that would be something to talk to us about. Like, if you're looking at your PSLF count, this is after you submitted an IDR application. Let's say you're switching out of SAVE into another income-driven repayment plan, and you're not seeing those months count, then reach out to Lindsay and I. But then it gets complicated because it's a time limited amount. It's a 2 month processing forbearance. Then the forbearance type switches. All that's to say is it's not particularly intuitive. It depends on the forbearance. Totally agree with Lindsay's like comment. Reach out to your servicer to ask what types of forbearance you're in and when, because that is important related to public service loan forgiveness progress.
All right, if there are no other questions, we will end for today. Thank you all for joining us these last couple of weeks. Hopefully you found it helpful.
Thanks, everyone.
All right, thanks.